Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. You've probably already heard that Brian Steele has filed a motion to recuse in the YSL case. And in the event you haven't heard, guess what? Judge Glanville denied it. And I think we all knew that he would do that in spite of the mountain of work that went into it and the precision of the detailing of the facts. I'm going to take a look real quick here at the motion and go through a little bit of it with you. But before we get there, there's an old joke about when is a door not a door? And of course the answer is when it's ajar. And this is one of those situations where a motion is not really a motion. It is essentially stored ammunition for appeal. The problem with most judges, and I know a lot of them, and most of them I think very highly of, most of them are very ethical. Most of them would not be caught dead in a situation like Judge Glanville is caught in. But if you were to go up to them and have a ruling that went against you and say, well, you're biased and I want to recuse you, that judge would fight you to the ends of the earth to prevent being recused because he does not see himself as biased. He sees himself as someone who made the right call, did the right thing, and here you are coming after him for it. Now that's not uncommon that happens. In fact, I've seen a lot of the email that I get actually is from people who say that the judge, worked with the prosecution or worked with the other attorney to really put the screws to them. And okay, I get that. It's easy to think that. But for the most part, what looks like the judge and the other guy cooperating is really, in most cases, just the judge doing the right thing. But in this particular case, Brian Steele didn't file this motion to get the judge to recuse. He knew this judge wasn't going to recuse. This judge has denied everything or almost everything. He's overruled every objection, and he's pretty much told Brian Steele he's not going to get much of anything, and that's exactly what's happened. And it's kind of comical to think that a lawyer as smart as Brian Steele would file a motion that he knows is going to get overruled. But that's exactly what he did. And the reason it is so smart is because it was accompanied with an affidavit, because the motion is not self-proving. You can cite that, there's information in the record in this case that supports this decision, but when you put an affidavit on top of it, that is sworn testimony that has weight and has to be considered. So that's what he did. But again, he never expected it to be ruled on favorably. He never expected the judge to throw up his hand and say, oh, heck, I quit. What he expected was the judge to do exactly what he did.
He must refer the motion to another judge to hear the motion, but if any one of the conditions is not met, there is no error in denying the motion. And motions to recuse are viewed and considered by the appellate court for abuse of discretion.
And that right there was a shot across the bow. He's like, they're not going to reverse me because this is discretionary. And so, yeah, I'll just say things that, your motion didn't make it. And because it's a discretionary review, it takes a lot to reach that threshold of some judge abusing his discretion. I've heard it said that if reasonable minds can disagree, then it's not an abuse of discretion. In this case, I don't think reasonable minds could disagree, but we'll leave that issue for
Accordingly, the court's going to address each one of the factors as it pertains to both Mr. Steele's motion and, for shortness, Mr. Banks' motion. I find both motions were timely filed. I find that Mr. Steele's motion was, in fact, filed on Monday, which would have been the 17th of June. I find that Mr. Banks' motion on behalf of Ms. Bumpus was timely filed, as it was filed on the 14th of June at 10:40 p.m. Secondly, I find that in addressing the legal sufficiency of the affidavit. That means, was it sworn? Was it sworn before a notary is in proper form? I find Mr. Williams and Ms. Bumpus's motions to be, or I should say affidavits, to be in proper form. The third thing that the court has to review, and like I said, I reviewed, is the legal sufficiency of your grounds of the motion. And here's where the court finds that upon a review of Mr. Steele's motion and affidavit, as well as Mr. Banks' motion and affidavit, that both contain assertions bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state.
Let's talk a little bit about legal conclusions. First of all, a legal conclusion is a statement that expresses a legal point or a proposed result without including the facts that support it. So, for example, when you say the defendant is liable for negligence, that's a legal conclusion, but it's because it expresses the outcome without expressing the reasons for the outcome, without including the facts. So, when you say the defendant violated his probation, that's another legal conclusion. It expresses a legal duty without including the facts that create that duty. Now, I had my practice for years in Missouri, and Missouri is what we call a fact-pleading state. So we have to plead facts and not legal conclusions. And we would say, basically the defendant was negligent in the following respects, and then we would list the facts that support that, so that when you get to the bottom and have read through all the facts, you could certainly conclude, hey, that guy was negligent, which is exactly the way to do it. And a lot of times in other jurisdictions, particularly federal court, it's called notice pleading. You just have to put somebody on notice. The defendant operated his motor vehicle in an unsafe manner. Again, that's a legal conclusion. If you were to say the defendant operated his vehicle at a high rate of speed, believed to be in excess of 50 miles an hour in a 25 mile an hour zone, that pleads facts, and that's not a legal conclusion. The reason this is important is because in a pleading, particularly one seeking relief, legal conclusions they're basically ignored by a court. So when a court reviews a pleading to determine whether it contains enough facts to state a claim, it looks at facts, and it'll look at the end where it says, and as a result, the defendant was negligent, or as a result, the judge should recuse. It would still be okay because there are all the facts that go before it. Now, that's a long way of getting to the point of saying it is very difficult to read a pleading and always understand what is a fact and what is a legal conclusion. But we're going to look at the motion and affidavit now and see if we can assess whether or not there are legal conclusions as opposed to facts, such that Judge Glanville would, of course, be required to recuse himself from further action in this case. So let's take a look at that now. So this is the motion. Comes now Jeffrey Williams by and through undersigned counsel and hereby files this motion to disqualify and recuse Judge Glanville. Undersigned counsel represents Mr. Williams. Okay, that's a fact. The jury trial of multiple accused persons commenced on January 4th, 2023 before the Fulton County Superior Court Judge Glanville. Again, that's a fact. The trial is expected to last at least through the end of 2024 calendar year. That is, of course, speculation, but it is at least cloaked in fact. On Monday, June 10, within 5 days of the filing of this timely motion, this court, along with the prosecutors, engaged in an unlawful, improper ex parte meeting with, among other persons, a sworn witness, Kenneth Copeland, for whom an order of use immunity had been issued on Friday, June 7th. No notice of this ex parte meeting was provided to any attorney for any of the criminally accused in the case. So that also is a statement of fact. In fact, the accused and their counsel were in the dark that this Star Chamber meeting occurred. Well, now you're kind of getting into a little bit of a legal conclusion, because calling this a Star Chamber is characterizing the facts. You're sort of gilding the lily here, and there's no need to do that. There's no need to characterize this as a Star Chamber meeting, because any reviewing court would automatically understand that's the case. Mr. Copeland had previously been called to testify, and it goes through all of this stuff that happened. So it comes down here and it says, judges shall accord every person a right who has a legal interest to be present. This is the rule that I cited. And I said, this is one of those things that a judge just always should never do. And I think I've seen a lot of other people discussing this, and they all seem to hold the same opinion. The only person who apparently doesn't hold this opinion is Judge Glanville, which either indicates that we're all wrong and he's right, or perhaps it's the other way around. Who knows? I know, but, At any rate, so the court violated this rule, and the court rejected the undersigned counsel's substantive requests for information. Undersigned counsel declined to join in the antics in ignoring rules and ethical provisions, and declined to provide information requested by the court, relying on the State Bar Rule of Professional Conduct, which states in part that he shouldn't do that. And there's this wonderful comment that says the attorney-client privilege covers not only what the client tells you, but everything you learn in your investigation, which is different from most of the other states. Most of the other states don't have that broad of an application of the attorney-client privilege, and that's certainly not the case in military court. There is not such a great broad sweeping attorney-client privilege for soldiers, sailors, airmen, and Marines. The record reveals numerous instances during trial where the judge's behavior appears to have been biased against Mr. Williams' counsel and partial in favor of the state. So that's a legal conclusion. The record reveals other instances, too, when the court wrongly berated counsel in front of the jury. Well, again, that is a legal conclusion. But again, we're still in the motion at this point, and you can have a motion that has a few legal conclusions in it as long as you, at the end of the day, your motion is sufficient to carry the day. And we'll have to see whether we think that's the case. The Supreme Court is mindful of the extraordinary pressures attending a criminal trial. On the one hand, defense counsel is obligated to vigorously defend his client against all charges brought by the state. Likewise, prosecutors have to effectively and ethically prosecute the state's case to a jury. At the same time, the trial judge is charged with ensuring that the rules of evidence and procedure are followed, and that the proceedings are both orderly, ethical, and fair. When these several interests come together in the courtroom during trial, disagreements between the bench and bar are to be expected. The instances discussed above and in attached Exhibit B, joint affidavit, however, represent more than mere friction between zealous counsel and a diligent jurist. The judge's conduct, as discussed above and herein, created the impression that he harbored an inclination to be biased against Mr. Williams and his counsel and partial toward the prosecution. Well, that is absolutely, that entire run-on sentence there is certainly a legal conclusion. There's no way around that. But again, we're not to the factual portion of the affidavit yet. So let's go take a look at the affidavit and see if it contains sufficient numbers of what I would call reasonable facts that would provide the judge with notice that his behavior was beyond the pale. And let's see if it raises the bar such that he should have recused. So we're over the age of 18, suffer no legal disability, which means they are essentially qualified to testify. On Monday and thereafter, affiants learned the following events in fact occurred outside Mr. Williams' presence and outside of the affiant's presence and in a Star Chamber-like environment. So you strike the Star Chamber-like environment, that's a fact, and as a result, that meets the standard. On Monday, June 10th, undersigned affiant, specifically Brian Steele, asked to have a transcript of whatever conversations were memorialized. Affiants requested the actual recording of anything discussed in this improper in-chambers meeting on said date. And again, you're characterizing it as improper, but clearly the rule supports the fact that it's improper. So again, that is far more fact than legal conclusion. There's no conclusion really built in there other than the improper, the use of the word improper. But the rest of it is purely factual. This court has obstructed Mr. Williams and below affiant from having an exact image of what was said. So he didn't provide that. That is obstruction. That obstruction alone shows the court is biased, as there is absolutely no privilege in communications in this court's chambers, as this court argued on June 10th, and there is certainly no attorney-client privilege under any stretch of the imagination, as this court asserted. Well, that's a pretty big, long, run-on sentence as well, but it is largely a legal conclusion. The court has obstructed having the exact image of what was said. That's a fact. That conclusion is then buttressed by that particular fact. I would have probably pleaded a few more facts here, but the bottom line is the fact that he obstructed access to the information is evidence of obstruction. This obstructionist conduct by the court shows that bias and this court is intrinsically intertwined in the facts of the case and has prevented Mr. Williams from due process, fair trial, effective assistance of counsel, right to know every material and critical happening in the case. So again, those are legal conclusions. The conduct has done this, but if you focus on the conduct, you don't have to assert legal conclusions. So in some respect, that's a little bit of a stylistic sort of thing on my part. I'm not really picking nits here. I'm just telling you that there are legal conclusions in here, but you don't pick out one or two legal conclusions in an affidavit and throw the whole thing out. Even if you strike that entire paragraph, other than the court obstructed Mr. Williams and below affiants from having an exact image of what was said, if that fact stands, you've got a fact that supports the need for recusal here. The court has also silenced witnesses by improperly issuing a show cause order for contempt. The court must be recused, a mistrial declared, barred by double jeopardy based upon prosecutorial misconduct and judicial misconduct. So we could very easily go through the rest of the affidavit and pick facts from conclusions, but the bottom line is I've reviewed it and I think there's plenty of additional facts in that motion that establish the need to have a second judge review this. And of course, that's really all they want. That's really all they need, because a second judge reviewing this would recognize the impropriety of the ex parte meeting and would take action accordingly. But I knew that we were never going to get there, because it's that last part of the motion there where he talks about must be recused, barred by double jeopardy based on prosecutorial misconduct. That's the heart of the motion. That's what he wants to get. So I think he's certainly made the grade as far as putting enough in the motion and the affidavit to get relief. But it's not my opinion that matters. It's Judge Glanville's, and he didn't think so. But I think in a reviewing court might very well have a different view on that, and as to whether or not he wisely exercised his discretion in denying the motion to recuse. So there is a statement that lawyers make all the time about if you aim for the king, you have to kill him. It's sort of an off-color way of saying, if you try to attack the judge and get him to recuse and he doesn't recuse, you're stuck with him and now he's ticked off at you. Well, I don't think there's anything to have been lost by Brian Steele in taking this shot, because as I said before, I think he's playing the long game here. I think he's going for relief on appeal or perhaps by writ. Having now denied this motion to recuse, I suspect that Brian Steele will file some form of writ. I'm not sure if that's available in Georgia, but certainly a writ of prohibition would be appropriate. File a writ of prohibition that says the judge has exceeded his jurisdiction by refusing to recuse in a matter where his bias and everything is evident. I think I'm a reasonable person, and I have absolutely no dog in this fight. But I can tell you that as a reasonable person, I look at this judge's actions, particularly in view of the rules here, and say, yeah, it looks to me like he's trying to hide something, or he's trying to stay on this case for reasons that go above and beyond just what a normal judge would do. I don't think he wants to admit his error here, and I think it's terribly appropriate for the judge, strike that, and I think it's perfectly appropriate for the judge to recuse at this point, and he should have. We'll have to see, how this all unfolds, but indeed, if there is ever a result in this trial, if we ever do get to a jury and they do get verdicts, and Williams or any of his compadres are held liable for what they've done or what they currently are alleged to have done, I think it will all be coming back because of this particular incident. And the best thing that the Georgia courts could do at this point is intervene, stop the trial, declare a mistrial, and start all over again. And the reason I say that is because there is no way that a verdict in this case is now going to stand. So that's what I have for you today. Thank you so much for watching. If you have the opportunity today, do something nice for somebody, and then come on back here tomorrow and sit down with us, and we'll talk about something else interesting and fun. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.